NBC's Dasha Burns is outside the courthouse in Fort Pierce, Florida. Ken Delanian is NBC's Justice and Intelligence correspondent, and Glenn Kirshner is a former federal prosecutor, MSNBC legal analyst, and host of the Justice Matters podcast. Okay, Dasha, what is going on in court? I know there's a lunch break now, but before lunch, we got to note that things were really heating up. What's happening?
Yeah, some spice in the courtroom here in South Florida. Look, today the defense attorney for Walt Nauta laid out his case for this motion to dismiss, alleging that the special counsel Jack Smith's decision to charge Nauta was based in selective and vindictive prosecution, essentially saying that this was a form of retaliation against Nauta for not cooperating properly with the investigation. Now, after Stanley Woodward, Nauta's attorney, made this argument, it was the prosecution's time to refute that. Well, David Harbach, arguing for the special counsel's office, got a little bit passionate in his argument. He said that Woodward's arguments were difficult to sit through, called it a garbage argument to begin with. And in a back and forth with Judge Cannon, at one point, things got so heated that Cannon told Harbach, "I'm going to ask that you calm down." So a lot of flurry in this courtroom right now. The arguments for the first motion to dismiss just focused on Nauta, just wrapped up. The second motion to dismiss will be addressed after lunch. That's focused on all three defendants, Nauta, De La Vieira, and former President Trump, where the defense is arguing that it should be thrown out because of procedural failures, essentially saying that the indictment fails to set forth in plain language actual violations of criminal law, and claiming that it's instead a personal and political attack against former President Trump, which, of course, the prosecution does refute and is going to refute in court today. Chris?
Of course, Glenn, I wasn't there. I only know what I'm hearing from our folks who are. But it sounds like some of the frustration that the prosecution has with this case overall is maybe starting to come to the surface. This is not the first time that either one of the prosecutors or, frankly, a lot of legal analysts have said that some of these motions are just, as she said, garbage arguments. So talk to me about whether you think there is merit in either of them that are being argued today. And frankly, with the number of motions the judge has to get through, do you think today's hearings were even really necessary? Should they have been prioritized?
Yeah, Chris, to start with your first question, these motions are meritless, and I understand the prosecutor's frustration. Let's take Walt Nauta's claim that he's being selectively prosecuted. People should know the leading Supreme Court case on the issue of selective prosecution arose out of the Vietnam draft. There were 670,000 non-registrants, people who failed to register for the draft. Of those 670,000, the Department of Justice prosecuted only 13 people. Those 13 defendants screamed bloody murder, claiming their indictments should be dismissed because they were being selectively prosecuted. The Supreme Court rejected those claims and set an extraordinarily high bar for a litigant, a defendant, to successfully prove selective prosecution. We don't have enough time to go through the test, but I can tell you, I teach this to my criminal justice students at George Washington University. Walt Nauta's case doesn't come within 100 miles of that very high bar. So I can understand why the prosecutors use what is really strong language. If they're calling it a garbage motion, I would call it a frivolous and baseless motion, which should have been resolved on the papers with no need for an evidentiary hearing or an oral argument. That feels like the judge continuing to slow walk the case without even setting a trial date.
So, Ken, we also got some new information about this case from a court filing yesterday about documents that were found in Trump's bedroom at Mar-a-Lago. This is another kind of wild part of this story. Tell us about it.
That's right, Chris. This court filing described what happened after the FBI did that search of Mar-a-Lago and grabbed up all those classified documents, when prosecutors believed there were still some classified documents the FBI didn't find. They had reason to believe that from witnesses and other evidence, and there was still an outstanding grand jury subpoena, so they instructed Donald Trump's lawyers to search for those documents, and they conducted various searches, and they came up with 2 additional sets, 4 in an office and 1 in Donald Trump's bedroom. And the judge noted that she didn't see an excuse for why Mr. Trump didn't know that there were classified documents in his bedroom. But prosecutors painted a picture of obstruction here. They argued that the lawyers really weren't making a good faith effort and that people were moving documents around while the lawyers were searching. And they also pointed out, this was a new revelation, Chris, that they had evidence that Donald Trump, once he realized that the FBI was asking for the surveillance video at Mar-a-Lago, he instructed his employees to make sure they were moving boxes outside of the reach of that surveillance camera. Now, that was not in the indictment, but it appears to be a new allegation of obstruction of justice, Chris.
Glenn, I just want to punctuate what Ken just said and read to you the way the Washington Post reported the second part of this. Buried in the supporting documentation for one of the motions was a document that contained a new public revelation. Once Trump realized that security cameras at Mar-a-Lago could capture his employees moving classified government information that officials were attempting to retrieve, he allegedly ensured that they would avoid the cameras when moving boxes. So what do those 2 things about documents in Trump's bedroom and moving boxes mean for this case?
You know, it is additional devastating evidence of obstruction of justice, of mishandling classified information, and perhaps of further evidence of violation of our nation's espionage laws if those boxes contained what's defined as national defense information. But, you know, going to the next motion that I guess will be argued after lunch, Donald Trump's attack on the sufficiency of the indictment. His lawyers claim that there is some infirmity in the language that the prosecutors put in the indictment. I think it's also a frivolous motion. But let me just read one sentence of what Donald Trump's lawyers claim in their attack of the indictment. They say that the indictment fails to clearly articulate a crime and instead amounts to, these are Trump's lawyers' words, quote, a personal and political attack against President Trump with a litany of uncharged grievances, both for public and media consumption, close quote. Chris, that is like an angry tweet masquerading as a legal filing. I understand and appreciate why the prosecutors who are seeking a fair and timely trial, not only for the defendant, but for the American people who need this case resolved, I can see why they're frustrated.
So, Ken, I also want to ask you about something that Donald Trump posted the other day. Now, we know that for a long time he has criticized the raid on Mar-a-Lago, but he says that the FBI was authorized to use deadly force during the raid at Mar-a-Lago, kind of implicating maybe that there was insinuating something nefarious was going on there. Was it?
Chris, he didn't insinuate it. He alleged it, and so did many of his supporters. And this is a really disgusting case of disinformation, Chris. What they are talking about is a standard form that was included in the warrant package, which was a DOJ statement of policy that federal agents are authorized to use deadly force when their lives are threatened. By the way, so are you and I, Chris, and Glenn. That's just standard self-defense law. But there was a document that explained when they could and couldn't use deadly force in the context of a warrant search, and FBI agents say that that is generally included in the supporting documents to a warrant. Donald Trump's lawyers included that in the filing. Some conspiracy theorists started tweeting about it, saying that it was an alleged assassination plot, that essentially Joe Biden had ordered federal agents to authorize them to use deadly force against Donald Trump, who, by the way, wasn't even there when they served the warrant. And then Mr. Trump put it on Truth Social, and there are going to be millions of people who believe that. It's just not true. The FBI issued a statement underlining that this is standard operating procedure. There was no specific authorization for any kind of force during the Mar-a-Lago search, Chris.
Glenn, we're completely out of time, but I have to ask you your reaction to that.
I join Ken's description. This is disgusting disinformation. It's planned to deceive people, and unfortunately, there are some folks who are going to be gullible enough to fall for it. Every law enforcement operation, every law enforcement officer can exercise deadly force if it is necessary to repel a potentially lethal attack. This is more of the same that we've come to expect from Trump and his loyalists.
Dasha Burns, Ken Dilanian, and Glenn Kirshner, thank you all very much.